Okay, we're here in Module 5, and this is an FAQ about the most frequently asked legal questions I get. Huge disclaimer here, you guys. I'm not a lawyer, so if you have questions about any of this, you need to talk to a lawyer. This is just my experience speaking here, but I think understanding other entrepreneurs' experiences about things that are legal matters can be very helpful. So the number one question that I get from entrepreneurs is usually about intellectual property. What is intellectual property? Let's define that. Intellectual property is any type of product, creation, or design that is created and owned by a company or an individual. Now, to enforce ownership of that creation and also solidify the right to use your own intellectual property, you have to do one of two things. You have to reserve the rights to that creation, to that property, at one of two United States offices. Those offices are the United States Patent and Trademark Office or the United States Copyright Office. I'm going to talk about the difference between trademarks and copyrights now. A copyright typically covers a written work. So this could be a book or a piece of literature, music or a painting or some type of work of art. Audio and video materials are also considered things that can be copyrighted. Here's an interesting fact. All work is actually automatically copyrighted at the time of creation. And I always recommend to my coaching clients, anytime you do something, just put a little C and a circle around it to tell people that. However, if you want to enforce your copyright, you have to register it. That means you're going to need to fill out paperwork and file it, send a check in and file it with the United States Copyright Office. This is so easy and something you can do yourself. You don't need an attorney to help you file a copyright. Now, let's talk about trademarks. Trademarks typically cover words, names, symbols, sounds, or even colors that distinguish goods and services from those manufactured or sold by others. So typically a trademark has to do with your brand. Examples of trademark, two that I really love are the ding, the Southwest Airlines ding when you get on the plane. That ding is trademarked. And another interesting trademark is the Tiffany blue color that Tiffany and Company uses for their packaging and for their brand. Those are just two examples of how a trademark is representative of a company's brand. Now, you can search for trademarks on the US Patent and Trademark website, but I do not recommend attempting to file a trademark without an attorney's help. It's hairy. I've tried it and I had to contact an attorney in the middle of the process to help me finish it. Now, another frequently asked question I get from a legal standpoint is, I want to print quotes on stuff. What quotes can I use? What's legal? So because I'm not an attorney, the only thing I am comfortable saying is that you either need to have permission to use a quote or it needs to be in the public domain. Now, definition of the public domain, like what is public domain? So I'm going to walk you through that definition. Public domain is all creative works to which no exclusive intellectual property rights apply. And this might be because the rights have expired, or maybe somebody's forfeited their rights, or they have intentionally waived their rights, or simply because the rights may not be applicable to a situation. In public domain, copyrights typically have a 75-year term. This is a little bit of interesting history for you. But in 1998, Congress extended the copyright term for 20 years, giving works published between 1923 and 1977 an expanded term. So, interestingly enough, works from 1923 just hit public domain on January 1st of 2019, this year. And works from 1924 will be available next year, and so on and so forth. And again, as with many legal things, there can be exceptions and nuances to all of the things I'm telling you. So if you're in a situation where you have a question, if you're considering publishing anything after 1923, you may want to talk to an attorney. And another question I get is, how long does copyright protection last? So for works that were created after 1923, the copyright lasts the life of the author plus an additional 70 years. So this means that any copyrights that you or I file, we will not be responsible for renewing once we have filed that copyright. Now, if you, for some reason, have anything that you've created that you are concerned about your descendants needing to inherit and manage, you're going to want to talk to an estate planner attorney, or an intellectual property attorney to help you figure out the right way to set that up for your business. As always, if you have any questions, you can use the link at the bottom of this post to fill out a question on the Google form, or you can post those in Slack. I'll see you guys in the next video.